Hi, it's John Goodman again, and you know why I'm excited. I am recording this video about changes to the Real Estate Commission approved contract that have been made in 2021 for use in 2022 and in subsequent years until they change it. The next thing we're talking about is a water rights review deadline, a water rights examination deadline, and a mineral examination deadline. I'll show you the exact language right now by doing the screen share thing, because this is worth taking a peek at. So I click here, I click there, and you should now be seeing a portion of section 3, the dates and deadlines chart. And you will see the Division of Real Estate has added in a water rights examination deadline at row 28. And the Division of Real Estate has added in a mineral rights examination deadline on row 29. Well, how cool can that be? But before we talk about that, we have to wonder, like, how have we lived for decades without a water rights examination deadline and a mineral rights examination deadline? And the way we've lived for decades without that is that water rights and mineral rights are considered real property rights. They're considered real estate. And so the buyer already has title related outs under the contract. For example, the buyer has a record title objection deadline and off record title objection deadline. And so if the buyer, perhaps with the assistance of a lawyer, did a title analysis of the water and was not content with the title rights associated with the water, the buyer could bail on the contract using off-record title objection deadline. Same thing with minerals, But now the Division of Real Estate has decided to add in these specific deadlines for these topics. Well, it's a cool concept, but there's some details that we got to pay attention to related to this. So one of the details is we're just in the habit of putting in dates in these blanks. So for example, with the water rights examination deadline, we might put in a date, the date that I'm encouraging you to put in, something like mutual execution of contract plus 14, or the specific date, 14 days out. If the contract is born on day 0, MEC date, I'm encouraging you to set the water rights examination deadline 14 days out or more. Same thing with mineral rights examination deadline. Now, I know that what the lawyer suggests is not necessarily what you can accomplish in the marketplace. I'll get there in a minute. I'll talk about the timing for a minute, in a minute. But right now, I'm encouraging you to set those deadlines 2 weeks out in the contract. And we would normally think, well, if there's this water rights examination deadline, then if my buyer is not content with the seller's ability to convey the water rights to the buyer, then the buyer has the opportunity to object and potentially bail or terminate. Well, we got to keep reading. So I am getting some Zoom stuff out of the way, and I am sliding down. Actually, I slide up. Let's look at the actual language of this contingency. It's in section 2.7.6 of the contract. Water rights review deadline. Buyer does or does not have the right to terminate if examination of the water rights is unsatisfactory to the buyer on or before the water rights examination deadline. So a few things to note here. One of them is that if the buyer has this expectation of being able to terminate based on dissatisfaction with the quality of the title to the water, then the buyer and you, as the broker working with the buyer, need to check this internal box. Don't be a broker who leaves this unaddressed, fails to check either box. There are some places in the Real Estate Commission approved contract where it says, if you don't check either box, then we're checking a box for you. They haven't done that here. It creates ambiguity about whether your buyer has the ability to bail based on the water rights examination deadline. You want to check the box so that your buyer has a termination deadline if your buyer is not content with the title to the water. So then that's one action item. The other thing that I think is worth talking about is when you look at where these deadlines appear in the dates and deadlines chart, they appear in the inspection and due diligence section. They appear just above inspection termination and inspection objection. And at the time I'm recording this contract, inspection objection, inspection termination deadlines, the market seems to be setting those deadlines sort of 10 days into the contract, 7 to 10 days in the contract in a garden variety residential real estate transaction. And my concern is that brokers will be setting the water rights examination deadline and mineral rights examination deadline 7 to 10 days in the deal. Why is that a concern? Well, it's a concern to me for two reasons. One is the contract and other things make it pretty clear that you should not be conducting this water rights examination. Neither should you be conducting an analysis of the mineral rights. That would be considered the unauthorized practice of law. And so who does conduct these analyses? Lawyers conduct these analyses. And at the time I am recording this video, I don't know if this will always hold true, but there's not only a shortage of people to drive trucks, and there's not only a shortage of people to unload shipping crates at docks, but there is a shortage of lawyers. And it's extraordinarily difficult. It will be extraordinarily difficult to get lawyers to evaluate the title to the water or the mineral rights, Sorry, that was a rookie mistake there. Or the mineral rights in a 7 to 10 day period. So that's one of the reasons I encourage you to push it out, these deadlines out to 14 days. But there's another reason. What happens if there's a contract where the water rights examination deadline passes, say after day 7, but the off-record title deadline is still alive on day 14? And there's a problem that's revealed about the water in between day 7 and day 14. Can the buyer use the off-record title objection to object to something about the water rights? I don't know the answer to that question. It may take some time for the courts or the drafters of the forms to sort those things out. But when you're on the buyer side of the transaction, you don't want to be that test case. You don't want to be the guinea pig. So what I'm encouraging you to do is write your offers so that the water rights examination deadline and the mineral rights examination deadline sync up with the off-record title objection deadline that is more like 14 days into the deal, rather than 7 to 10 days in the deal. And of course, as a lawyer, I would like it even further out, but try and get all 3 of those deadlines, mineral rights, water rights, and off-record title objections, to line up on the same date, sync them up 14 days or more into the transaction. Those are the action items I've got for you. Remember, we live in a complicated world. Be careful out there.